Today, I will have to start with a mention. This order, it will be delivered in the second half. There's some mishap I forgot in the bungalow. Yes.
Now, item 45 and 46. On the last occasion, that is on 29 April. This Honorable Court has passed an order to hear the matter out of 10. Although it is listed in the hearing list, it is the last hearing matter, which is not likely to reach early. So this matter relates to declaration of results of constables, the excise department lordships. So may I pray that this item may be upgraded and take up as first hearing item, lordships.
Okay.
Otherwise, in the second half, lordships, there is a seminar, and I'm very hopeful that the attendance will be good. The members of the bar will be benefited. If it is permissible, I'm making an unusual request also to suspend the proceeding in the second half so that to continue with the seminar.
I don't know, that may not be possible. That may not be possible, but
my another friend has told me that they have some hearing part matters.
That may not be possible.
The possible action, lordships, may accommodate.
Because the master of the roster is somewhere in a distance, distant location.
Very well. Nice.
My lord, I beg to mention item number 25, 26, and 27. Here I am appearing for item number 25. My lord, if this matter can be taken up next week.
You have taken consent of all the
My lord,
sides?
yes.
Okay. With consent of the other side, Mr. Takakichu, learned counsel for the appellant in Criminal Appeal 2 of 2019. Prays for an adjournment. Prayer is allowed. List after a week as prayed for.
Lordship, I'd like to mention item number 29, 30, 31, Lordship, on behalf of the till 33, Lordship. 29 to 33 on behalf of the Advocate General, Lordship. This matter can come up after 3 years.
You've taken consent of the other side?
Yes.
Okay. Both sides are represented. Prayer for adjournment is made by the learned government advocate on behalf of the learned Advocate General, who's unable to do the matter today. Next para. Accordingly, list after 3 weeks as prayed for. It's a 21 matter. This first revision is 2021 matter. We give a fixed date, it'll be better. Give a date after 3 weeks.
19 matter.
Huh?
But you need April 1st, 20.
Give the date. What's his name?
Lordship, I have no instructions as which date to fix, Lordship. It depends on the Advocate General.
No, because this is a 21 matter. We really can't adjourn it for long.
What's the fix on 3rd of June?
3rd of June. Okay, make it 3rd of June.
May please, Lordships. My lord, I beg to mention item number 23 in hearing this matter. My lord, we have a consensus created. This matter may be.
Item number
23 of in hearings.
23 is not in hearing, it is orders.
Yes, and then 28, my lord.
28.
My lord, we have a consensus created. This matter may be listed to 2 weeks now.
Okay, both sides are represented on the prayer made by learned counsel for the appellant, the list after 2 weeks.
I'd like to mention item 35 from the living trust, Lordship. This is a consensus praise, the prayer is meant to make any listed after 2 weeks, Lordship.
Okay. Same order here, item 35. Both sides are represented on the prayer made by the learned APP for this state list after 2 weeks.
May be the lordships. Lordships, I beg to mention item number 42, 43. I pray the matter be listed after a week. Lordship, this is a consensus prayer. Item number 42 and 43.
Okay, with consent of the other side, Mr.
Sentilo.
Sentilong, learned counsel for the appellant in W8 20 or 2025, prays for adjournment. Prayer is allowed, list after 2 weeks.
Adjourned.
Maybe the lordships.
Adjourn. So, hearing possible.
Maybe the lordships. Just I'd like to mention hearing item 39 and 41. Bishop, if we can have these matters next week, by all.
39, 40.
39 and 14, in the those matters. For the appellant.
Okay. Both sides are represented. The prayer made by learned counsel for the appellant. List after a week.
Bishop, similar prayer for item number 41. They also and for the appellant.
Okay, same order. 41.
Bishop, there's an interim in this matter.
In 41.
Yes, my lord. Yeah.
Okay, 41, interim order passed today stands extended till the next date of listing.
Obliged.
For admission, item number 4.
I think it's that upon this matter too, by that statement.
Heard, Mr. Your name?
I am in.
I, M.T. Longchair, learned counsel for the petitioner. Refers to the affidavit of the service filed on 21/2/2026 and submits that notice has been served on the respondent number 2. Full stop. None appears on call for the respondent number 2. Right, so government advocate is present. Yes. Mhm.
Service to order accept ways. Order dated 18.
Yes,
My lord, you judgment is page 1 to 8. What is that petitionary filed for an RDI? Then the petitioner filed before the Nagaland Information Commission, which stated to furnish the required documents to the petitioner. Then what happened is this, my lord. The respondent approves the NIC, Nagaland Information Commission, for a modification, but without issuing even notice to the applicant, petitioner. The same was
where is your application for information? Which page is your application for information?
(29/09/11) of 2024, page 54 to 56.
And where is the order of the Information Commission?
Page 65. Then page 67 is the order. By which we were summoned. Then hearing was conducted on 19/4/2023, page 69, my lord. The decision is page 72.
You have this right to information Nagaland rules. Right to information Nagaland rules. Change करो।
My work was still looking at like Nagaland, like the information, not of Nagaland, but still looking in that.
Yes, who's appearing for this? You are appearing for the state? Yes, please tell us why we should not admit this appeal for hearing.
The information, the first committee report, the RTI is sought by the petitioner is regarding the first committee report. The first committee report was not officially documented. So that was set aside and the department has applied and filed an application for extension of time to submit a committee report. And so in pursuant to that, your lordship, time was granted. And the department has constituted a new committee. And in fact, the new committee has submitted its report and stood approved. So your lordship, it is open to the petitioner to file an RTI now.
No, but you see, whether the commission has a power to review its own order.
That your lordship, the NIC will be in the best position to answer.
But they don't appear.
The presence is required, your lordship. Because
You see,
it's okay with that.
in a writ petition, we can't issue warrant of arrest to bring the information commissioner here. So what can we do? We'll admit it that
Records are here.
you please tell us, we are looking at this information, Right to Information Act, whether under the Right to Information Act or under the Nagaland rules, the commission has a power to review its order. That's the only legal issue arising. It's not there, and we can't compel the appearance of the Nagaland Information Commission. If you want, we can recommend to the government to remove the person for not appearing in court. If you want that sort of order, we are ready to do it. But you'll have to make a prayer. We'll record your prayer and then say that. Next paragraph. By filing this intercourt appeal against the judgment and order dated 5/8/2025 passed in WBC 135 of 2024, the Next one, the case of the appellant is that he had filed an RTI application and agreed by the decision of the PIO, the petitioner had preferred an appeal before the State Information Commission. Full stop. The State Information Commission,
Nagaland, specific Nagaland Information Commission instead of state. Nagaland Information Commission, that is page 69.
Nomenclature is Nagaland Information
okay,
Commission.
Nagaland Information Commission. Had passed an order dated 28/4/2023
Yes.
in the appeal filed by the petitioner. Full stop. However,
I was granted. Nata. Decision is page 72.
you please write an order and give it to us. You write an order and give it to us. How to write?
My
Either you allow us to proceed.
yes.
There may be shortcomings, and if the orders there are shortcomings, we have still higher for.
I apologize.
No, we don't need an apology. We're just telling you. So thereafter, the Agriculture Department, no, sorry, the PIO and the Deputy Secretary to the Government of Nagaland from our Agriculture Department made a prayer for modification of the Commission's decision dated 28/4/2023 and by entertaining the said application, the Nagaland Information Commission by the impugn order dated 22/5/2023, modified the order dated 28/4/2023. So accordingly, the said order dated 22/5/2020 5/2020 22 लिखे से 8 से 23 keep it. And see, there's a short technical problem. Come to page 51. First come to page 76.
Malo.
76, you are there?
Malo.
The date of the order is 22/5/2023. Correct?
Malo.
Now come to page 51. First prayer is for an order dated 22/5/2022. Now what to do? You're challenging an order of 2023 and your prayer in the writ petition is 2022. Okay, just say that we're filing filing WPC
This again,
176 of 2023, they said order was assailed by the petitioner.
yes, my lord. Indeed, it should have been. Yes.
Stop. Next para. The short question which arises in this appeal is whether the Nagaland Information Commission has a power to has been vested with power under the statute or rules to amend its order or to amend, modify, or or vary its order. First of all, on the said issue, this intercourt appeal is admitted for hearing by issuing rule returnable forthwith without requiring any steps to be taken. Next para. List the matter for hearing after 2 weeks.
My
For admission, item number 5.
In the first part of the order, we have said that none appears on call. In the first part of the order, we have said none appears on call for the respondent number 2. There you add the name Nagaland Information Commission. Respondent number 2, Nagaland Information Commission. Yes.
And still the additional by passing of order dated 13/4/2026. Relief has been granted to the petitioner, so it's been closed the infractions.
Okay.
The order may be placed on the court for future reference. I will have no objection to withdraw the appeal. But in a situation like this, it will be appropriate to impose cost on the state for taking the high court for a right.
Incidentally, when you have said about cost, are you aware of the legal tender in country? Which currency note is a legal accepted legal tender in our country?
The one which we are using.
No. You please take out any currency note you have in your pocket.
Yes. I have a 500 note.
I understand this. Not an issue. 2000 is banned, therefore you have only this. Now, you see in this note, you will only find the IOU by the governor of RBI. It says I owe you.
Yes.
So if money is an IOU, then what would be the legal tender? You have 500 rupee note, but still the governor says that if you give me this, I will pay you 500. So this 500, what will be the legal tender then? No idea. I think the note which I am referring to may not be available with anyone here. That is 1 rupee note, not even a coin. A 1 rupee note is signed by a finance secretary. And therefore, that is the only legal tender. If you go to RBI, deposit this 500 rupee note, they will just take out 1 rupee notes and give it to you. So that is a legal tender. So we impose a concept. You want us to impose? Okay, heard. You reminded me of something which we read in school. Mr. N. Angami.
Yeah, under me.
K. Angami, I'm sorry. Mr. K. Angami, learned government advocate. Your designation is government advocate, senior government advocate. Upon instructions has submitted that during the pendency of the intra-court appeal, the petitioner, the respondent, Sri Nung Shimeren, was appointed as computer, COMPUTOR, computer dash Roman 1. Oh, no, no. During the pendency, the interpret appeal, the competent authority, i.e. the Commissioner and Secretary to the Government of Nagaland, Works and Housing Department, in pursuance of the P&AR Department's approval, wide UO number 16 dated 7/6/2026 had passed an order that for retirement purpose, the date of joining for computation of length of service in respect of the respondent Sri Nungshimren would be 11/1/1993 and not 26/2/1991. A copy of the said order dated 13/4/2026 has been produced, which is made a part of record. Next para. Accordingly, the learned senior government advocate submits that the matter has now become infructuous and therefore the matter be closed as infructuous. Full stop. Next para, Mr. City. Huh?
7/4/2026. Not cheap. Annual overhead 7/6/2016 was.
No, it is order number 16, dated 7/4/2026.
Okay.
That is the number. We have written that on. Mr. City Jamil Lanet, Senior Counsel, assisted by Mr. Ayenchen, as well as Mr. Joshua Seki, Lanet Counsel for Respondent number 2 are present. So matter stands dismissed. Being having it rendered infructuous. This IA also closed. In view of order passed in writ appeal, the IA stands closed.
For admission, item
Mr.
number.
Jamil. Mr. Jamil, I am sorry, I forgot to add one more line to that 1 rupee. This 1 rupee, incidentally, if you check up the your internet, you will find that it is being traded at a premium. If you have an old 1 rupee note, it may fetch you a lot of money. So now instead of this 500, you can convert yourself to 1 rupee.
For admission, item numbers 6 and 7.
Please, my lordships. Lordships, this is for deletion of names, respondent number 22 and 23. In
Yes.
bill number 44.
This IA
IA.
for deletion of the names at serial number
Serial number 22 and 33. Inadvertently, they were added in both the other repetitions,
22 and 23.
22 and 23.
Okay.
In
Yes.
repetition number 44.
Any objection to this prayer?
I'm not representing those respondents. I'm not representing.
Okay, you are appearing for the government,
No, my lord. I'm representing for the private respondent.
private respondents. Then who is for the government? State of Nagaland, represented by Chief Secretary and the Commissioner, Higher Education.
B. Shimobi is absent today, Lordship.
But this has been filed since January, Lordship. But
No, not that. What do you call? If she has no objection, then we allow this prayer for deletion of names.
only deletion of respondents, yes. Yes.
Okay. But this said, Jimomil and counsel for the applicant, as well as for her given name, the government advocate, and you are appearing for respondent numbers. You are appearing for which respondents? All the private.
Before the date, 10 to 21, and 23 to 32.
Okay. Next paragraph. By filing this interlocutory application, comma, the applicants who are the appellants in the connected writ appeal are praying for deleting the names of respondent numbers 22 and 33. 22 and 33
22 and 33, Lordship.
From the area of parties in WA 44 of 2025. Full stop. Next para, it has been submitted that the said respondents have been impleaded in another writ appeal, and their names were inadvertently impleaded in the connected appeal. Next para, considering the explanation tendered, comma, the prayer made in this interlocutory application to delete names of respondent numbers 22 and 33 is allowed. This application stands disposed of. And
Oh, my Lordship.
no, you will have to file a amended cost title here.
Yes, Lordship.
In the writ appeal, you say, heard so and so, in view of the order passed today in connection with IS Civil 9 of 2026, comma, the learned counsel for the appellant shall provide amended cost title to the registry for being incorporated in the writ petition and for consequential updation of the data in the CIS system. Full stop. Let the matter be listed thereafter, immediately thereafter.
Lordship, I need to mention item number 12 to 20. These are analogous matters, so this may be clubbed up together as analogous matter with item number 6. All are analogous matter, only the date of filing is different. Same judgment order.
Just a moment.
Only the difference
Just a moment. Just a moment.
the writ appeal number
Yes.
44.
Just give me some time. Eleven to 26. What can I get? But you have attached it, you have a copy of the paper because we can't read this newspaper. You have a copy of this publication?
Publication.
Huh.
But you in the paper, page 11, bottom.
We can't open it. You have stitched it.
Oh,
Page number?
Lordship, I have written there, somewhere at the corner.
Actually, page 11, bottom, second box. Eleven does not have a second box. Okay, the second one it is.
Lordship, the print,
Just a moment. Nine. Nine. This one. 9 o'clock, I think. 9:22. 9:22. One, two, three. Let's go. 8, 9, 1. 9, 22, 22. 22. 9, 23, 22. Yeah, 33, 34, 35.
तो दुल्हन है उसमें।
You see,
Lordship,
as per the last order of this court, 10/12/2025, Mr. Jivomi appeared and accepted notice for 1, 2, 3. Mr. Takakichu, London Council, accepts notice on behalf of respondent 4 to 8, 10 to 21, and 23 to 32. That means notice, and the order is that for others, notice has to be served by substituted manner. Now, the persons who are yet to be yet to appear were serial number 9, 22, 33, 34, 35. So this notice is only to 2.
yes, Lordship, there are some confusion here. The others were left out because they were not, they were not in the extension, last
We don't know
extension.
those things. We are just reading the order and looking at your advertisement.
Let the matter come up next week, Lordship. I will sort out the
Huh.
confusions.
No, you see,
Then,
Jivomi, we don't
this-
have a confusion. We are very sure we don't have a confusion. We are reading the order, we spent 5 minutes time on it,
yes,
and then we are telling you it's not a confusion. Now you will have to clarify. Next para. It is noticed from the order dated 10/12/2025 that on behalf of respondent numbers 1 to 3, 4 to 8, 10 to 21, and 23 to 32 were represented, and the respective learned counsel accepted notice on their behalf. Full stop. There are 30. There are 35 respondents in this appeal, and therefore notices were not served on respondent number 9, 22, 33, 34, and 35. As per the order dated 10/12/2025, notices were to be served in a substituted manner by publication in newspaper in respect of the remaining respondents. Next, but accordingly, the learned counsel for the petitioner placed for some time to address the court on as regards service of notice on respondent numbers 9, 22, 33, 34, and 35. Out of the said respondents, the names of respondent numbers. Who are the respondents who were struck out?
This we did not publish because these two names are going to be struck out.
You don't have that choice. Your notice becomes defective. Without order of the court, you can't have a choice that I will publish news advertisement for the A and not for B. Because for B, I am taking a different recourse. That choice is perhaps not available to you. Out of this, the names of respondent numbers 22 and 33 were struck off. Nonetheless, steps taken appears to be not in accordance with the order dated 10/12/2025. Accordingly, the learned counsel for the petitioner placed for some time to address the court regarding non-service of notice on respondent numbers 9, 22, 33, 34, and 35. Next, by list after a week as prayed for.
Lordship. Lordship, this item with April 44 may be separated and from with April 45. 45 to 20 may be club up together. Lordship. 45 to 20.
Did I send the order sheet also? No, order sheet is in.
With appeal 45 to 45, 51. 261, Lordship. All are under this matter. Same judgment. Item is Lordship 7, 12.
You all want all these matters to come up next week.
Lordship.
Okay, just take the item numbers. Item numbers.
Items 7, 12 to 20.
Okay. Here pass the same order.
And
Please-
item,
Please in a slip of paper, give the names so who are to be shown as present in the item wise. Otherwise, she'll make a mistake.
Lordship,
In whichever matters you are appearing, please
we shall
take
do
the
that.
names. So and so are present. Next on the prayer made by unconscious for the appellants. List after a week.
Strike out everything already. They're having advertisement on Zee Guitar responding.
Obliged Lordships.
For admission,
With the second file.
item number 8.
Thank you, Your Lordships. Your Lordships, this appeal is preferred against the judgment in order passed by the women's legal judge, whereby the appellant's challenge to the suspension has been rejected on the sole ground that a review has been conducted and a memorandum of charges was served during the pendency of the legal petition, Your Lordship. Your Lordship, the impugned judgment suffers from prima facie error of law, as the very single judge failed to consider the crucial and undisputable fact that Your Lordship, at the time of filing the writ petition, no review, neither review was conducted, review of suspension order was conducted, nor any memorandum of charges was served, was issued against the appellant, Your Lordship. Your Lordship, in the present case, the appellant was placed under suspension on 7th February 2025 in connection.
Pursuant to detention in custody.
Yes, Your Lordship.
So is a what you call review necessary in those cases where you have been taken into custody?
Yes, Your Lordship, such cases, Your Lordship, as per rule 10 of CCS, an intimation to the competent authority must be given to for office feelings on bail. And the review and the 90 days period will come from the end office feelings on bail. In this case, the appellant intimated office feelings on the competent authority on 2nd June 2025. And the 90 days was expired on 21st August 2025. Even after the expiry of 90 days, no case was taken to review or serve memorandum of charges against the appellant. And Your Lordship agreed by the indefinite suspension, Your Lordship, the appellant approached, filed a written petition on 7th November 2025. And during the pendency of the writ petition, Your Lordship.
But you were served with the copy of the memorandum of charges.
Yes, Your Lordship.
That give the dates.
No, Your 90 days, no review was conducted, nor memorandum of charges was served upon the appellant, Your Lordship.
Yes, but the finding is on 10/3/2026. You were served with the.
During the pendency of the writ petition, till filing of the writ petition, there was no memorandum of charges, no review.
Where is your list of dates? You were. You were taken into custody on
Custody on 5th February.
5/2/25. You were suspended on 7/2.
Yes, Your Honor.
On 10/3, you were served with the memorandum of charges.
Memorandum of charges issued on, as per the report issued, memorandum of charges was issued on 10th. However, a copy was served upon the appellant only on 23rd March 2026. Your Honor.
23rd March 2026. From where you are saying that?
Moment, Your Lordship, at page 64 of my appeal, Your Lordship, the review committee was set up only on 2nd December 2025, that is during the pendency of the litigation. Your Honor. 6 months was delayed to file counter affidavit, and during that period, everything was done. And
No, that's not the sequence which has been projected by the government. The government says that you were charged with commission of offence under POCSO Act.
yes, Your Lordship.
Now, you were released on bail
On 21st May 2020. Your Lordship.
2025, and thereafter the review committee was convened.
No, Your Lordship, as per the record is very clear, Your Lordship, at page 64 of my page 64, a review committee was constituted only on 2nd December 2025.
What is the date when you informed about your release?
Your Lordship,
What is the date when you informed the government about your release?
on 2nd June 2025.
2nd June.
Yes, Your Lordship.
It is correct to me. Intimation 2/6 of delay. The register 31/23 10 of charge sheet is calculated. Yes. 90 days of dissolution. Yes, you'll have to admit is for hearing. In this case, it appears from your affidavit filed in the writ petition that police in the meantime, for the offences committed, had submitted charge sheet on 23/10/2025. As per the counsel for the appellant, the intimation of release on bail was given to you on 2/6/2025. But the review was done only on 16/12/25. And they have admitted the delay. This date was perhaps misconstrued in the order of the learned single judge. Submission of charge sheet, the departmental charge sheet is only on 10/3/2026. She has made out a case for hearing.
Yes.
Hmm? Okay, heard Miss Learned Counsel for the appellant and solicitor and government advocate for the state respondents. By filing this intra-court appeal, the appellant, who is the petitioner in WPC 226 of 2025, has assailed the judgment and order dated 24/3/2026, passed in the said writ petition, or thereby dismissing the writ petition of the petitioner. Next, the learned counsel for the appellant has submitted that on the, or that after release, after being released, that she was, that the appellant was taken into custody on 5/2/2025, and on release of, on bail, the intimation of his release on bail was given by a communication dated 2/6/2025. So, however, beyond the period of 3 months, the review committee to consider this continued suspension of the petitioner took up the proceedings on 16/12/2025, and though charge sheet in the criminal proceeding was submitted on 23/10/2025, it is submitted that the finding of the learned single judge has been assailed. That's gonna issue rule returnable forthwith without forthwith. List of the learned counsel for the appellant shall serve requisite extra copies of the memo of appeal along with all enclosures to the learned government advocate within 2 days. Next paragraph. Liberty is granted to the state respondents to file their affidavit, if so advised. Next paragraph. List in the orders column after 3 weeks. So we give you time to respond if you want to. These factual aspects you'll have to clarify. We come for orders and thereafter it is for hearing.
Let me see. What's the topic about the PS score on one generation? It's getting properly. PS score
Orders, item numbers 9 and 10.
Lordships, and bearing on behalf of the appellant, counsel for the appellant. Counsel for the appellant is on bereavement to the lordship. But appellant letter may be this lordship.
After how much time? After
A week lordship.
after a week. Okay.
And lordship, as per the last order, the appellant were due to pay
Yes.
for preparation of paper books, lordship. And accordingly, I was informed that it's already been paid.
The paperwork is ready.
Preparation.
Paperwork is ready. Huh?
Paper book has already been received on behalf of
Huh?
Senki Anger. And money has also been deposited.
Both sides are represented. It has been submitted that the Learned Counsel holding the brief for the appellant is in bereavement, and accordingly, prayer for adjournment is made. Next paragraph. List after a week is spread.
Operation.
For orders, item number 11.
In one case, that record is not there. Just tell me which one matters there. Record was, original record is not there. Let's come back. Let's send back. Yes,
I have very instructional this morning to telephone contact to appear on behalf of the respondents on the Sunday too.
yes.
No. I say that I mean, so it's they are going to
In appeal, you want to file a counter.
don't go to by my power of. So they bother and my.
How much time?
Oh,
4 weeks.
I have to.
Make it 2 weeks. Make it 2 weeks.
It is true.
Okay. Okay. But Mr. I, Javed London, counsel for the appellant. And Mr. Enangami, Learned Government Advocate, appearing for respondent numbers 73, 74, and 75. Next, Mr. I'm forgetful. Learned Counsel enters appearance for respondent numbers 1 to 72. And submits that he's appearing on the basis of telephonic instructions and needs 3 weeks time to file his Wakalat law. So, clear is allowed. List after 3 weeks as platform.
For orders, item number 21.
Lordship, I'm the petitioner number 1, case Constantine PIO. So just this morning, my counsel's maternal aunt passed away. So if I may be allowed to hear on behalf of myself and the other petitioners.
You are not
Yes.
properly dressed, counsel.
In person.
In person?
No. Yes. Yes, you have information about this bar council examination. You have instructions?
For Parva's comments. And for respondent number 1.
Yes.
I have not received the instruction.
No, they will not be interested to give it. You see, it is in the interest of students and the budding advocates
Yes,
who want to join the bar to have an examination center in Nagaland. They are not demanding moon. And if the bar council doesn't give, then we issue a court direction. State cannot be deprived of a examination center for the students here. Her demand is not unreasonable, is it?
Yes, ma'am.
Don't put your litigation right examination center of
bar
examination.
The Lordship said the interim prayer will be considered today as the exam is scheduled next month.
What is the date of examination?
7/6/2026.
7.
6/2026.
Miss Esther Chakri, the petitioner, the petitioner number 1 appears in person and submits that her learned counsel is in that the learned counsel for the petitioners is in bereavement, as and accordingly she prays for leave to appear in person for herself and on behalf of 2 other petitioners. Most of the prayer is allowed, and the petitioner number 1 is allowed to address the court in person. Next para. You are the CGC.
Yes,
Yes, madam. Mr. Zedin Nuguli Leonard, CGSC. Is present. And for Bar Council, who is for 2, 3 and 4,
Respondent number two here, they entered in hearings last week. And.
but he's a regular, Mr. Forte is a regular council. Just see, he may have missed it. He's normally regular. This is item number
Name is not shown, I think.
21. His name is not there. Can you find out if he is available? We'll take it up because he must have notice. We won't pass an ex parte order. Just check in the bar if he is available. We'll take it up after some time. Just check up because he's normally regular.
For orders, item number 22.
After some time. Yes, for the government who is appearing.
Yes.
You file your affidavit? No.
No, madam, we have received the reports.
You have received the record.
Yes, madam.
You intend to file your affidavit?
Madam, then, if the, since the record is available, the matter will be heard. Madam.
Okay. Yes.
These are lordships. Lordships, while the deputy was in the judicial custody, a detention order was passed by the Commissioner of Police and District Magistrate Dimapur. By the order dated 22/1/2026, the detention review order is annexed page number 33, annexure 5, lordship. And in page 34, the grounds of detention have been mentioned. So specifically, the grounds have been mentioned: security of the state of Nagaland and maintenance of public order. Lordship, besides that, no reason has been assigned regarding in what manner the security of the state of Nagaland.
I understand.
Lordship.
It's very easy to, you see, you may be a fearless person. If bullets are fired all around you, you may not get perturbed. But it doesn't apply to me. Even if 1 kilometer away a bullet is fired, I may be afraid here. You have a gun license with you?
Lordship, in this case, there is no prima facie case the detention. There is no prima facie case the detention. Although there is an allegation that the gun was shot, but there is no allegation that it is the present detention who had shot the fire.
That is a matter of investigation. In your writ petition, in this writ petition,
Lordships. Your Lordship, moreover, the detention has filed a representation on 5th February 2026.
it's February 26.
And I've annexed that in page number 44, annexure 8. And prior to that,
approval order was passed. And the approval order is in page number annexure 9, page number 50 project.
50.
50, yes. So it
What is the date of approval order?
approval order is 2nd February 2026.
Yes.
So I respectfully mention that at the time when this representation was filed, the approval order was not furnished to the deputy. That is the contention of the deputy projects. There's a violation of the statutory and procedural laws.
Okay, then.
Moreover, in the detention order, it has been mentioned that the deputy has filed a bail application. But that itself would not suffice for passing a detention order in Rogers. Because there are no cogent materials to show that if he is released on bail, he's a threat to the security of the state or to the public order in Rogers. So there is no subjective satisfaction in respect of that. May I be allowed to rely on certain citations in Rogers? Ashia Agarwal versus State of UP and others. I'm relying on Bharat and Rogers. May I read the Rogers?
Just a moment.
Bharat and may I read the Rogers?
Just a moment. As per this page 50, the detention order, the question is to both of you. As per page 50, the detention order is till 21/4/2026. Has it been extended?
Yes, yes, my lord.
Yes,
By confirmation order.
confirmation order is in page number 68.
68.
68. Annexure 11A. By the confirmation order, his detention was extended for 103 months lodges. Till 21 July 2026.
Okay. Page number?
60A.
Capital A.
60
capital A.
Okay, 60 capital A. Okay.
Capital A is. That is after his representation was rejected, Your Lordships. I may be allowed to take additional grounds, Your Lordships, that the representation was filed on 5th February 2026. However, there was delay in disposing the representation. The order regarding rejection of the representation was passed on 12th February 2026, which I have annexed as Annexure 10, page number 59, Your Lordships. So on 5th February 2026, representation was submitted, and on 12th February 2026, the state rejected the representation of the detainee. Thereafter, again on 19th February 2026, the center rejected the representation of the detainee. So there is a delay. The rejection ordered by the center is annexed as Annexure 11, page number 60.
What is the period within which it is to be disposed of?
There is no specific period as such as to be act. However,
7 days to do it. This will be that. Because details will be circumstances in the case comes on.
So what is the period from the date of representation till the date of disposal?
representation was filed on 5th February 2026, and the disposal by the state is on 12th February 2026.
So 7 days.
7 days in project. And by the center, it's on 19th February 2026.
Yes.
There is an ample delay, and there should be a reasonable explanation with regard to that, Your Lordships.
But that's not covered by any of the grounds of your for challenge of this.
Yes, Your Lordship, I have not specifically annexed that appended in the grounds. However, I've prayed for taking additional grounds in my petition, Your Lordships.
No, you see, the state must have noticed before they respond. The Union of India doesn't know about this. Yes, you are
Lordship,
referring to the
besides that-
judgment.
Besides that, Your Lordship, there are two grounds in
We'll
the
take a short break and come back. Yes.
Lordship has per the allegation, the offences charged against the accused. It can be tried by ordinary court of law, your lordships. And the allegation against the accused, deputy in this case, your lordship, is that he was arrested only on the statement made by co-accused, but there is no allegation that the gunshots were imputed against him, your lordships. Those allegations have not been specifically imputed against him. And your lordships, the charges against the deputy only affects a specific individual. And in the grounds taken by the detaining authority, there is no mention as to in what manner his action has posed a threat to the security of the state of Nagaland. So the grounds taken are back and irrelevant, your lordship. And the offences charged does not come within the purview of public order, your lordships. And for this, may I be allowed to rely on one citation, your lordship? Kishore Mohan Bera versus the state of West Bengal. I'm relying on para 7, lordships. May I read, your lordships?
Yes.
In Dr. Loya versus State of Bihar, this court explained the difference between the three concepts of law and order, public order, and the security of the state, and fictionally drew three concentric circles, the largest representing law and order, the next representing public order, and the smallest representing security of the state. Every infraction of law must necessarily affect order, but an act affecting law and order may not necessarily also affect the public order. Likewise, an act may affect public order, but not necessarily the security of the state. These observations clearly bring out the distinction between each of the three concepts, and the three imaginary concentric circles helps to delineate the respective areas of the three concepts. A similar distinction between law and order and public order was also drawn in Pushkar Mukherjee versus State of West Bengal, and a caution was there expressed that the expression public order in Section 3(1) of the Preventive Detention Act 1950 did not take in every infraction of law, and that every disturbance of law and order leading to disorder would not be sufficient to invoke the extraordinary power under such a detention law, unless the act in question was such as endangered or was likely to endanger public order, lordships. So I'm respectfully taking the ground that the offense charged against the accused comes within the ambit of law and order and not public order. There is no allegation, even with respect that there is a threat to the security of the state, according to lordship. So even if one ground is irrelevant or valid, then the detention order is liable to be questioned. For that, I may be allowed to rely on one citation. Pushkar Mukherjee and others versus State of West Bengal, lordships. I'm relying on para 16. It's a short para, may I read, lordships?
Yes.
The argument was, however, stressed by Mr. Mukherjee on behalf of the respondent that the other grounds, these C and D, mentioned in the order of the district magistrate dated January 20, 1968, are more serious in character and may be held prejudicial to public order. We shall assume in favor of the respondent that grounds C and D are matters prejudicial to public order. But even upon that assumption, the order of detention must be held to be illegal. It is now well established that even if any one of the grounds of reasons that led to the satisfaction is irrelevant, the order of detention would be invalid, even if there were other relevant grounds, because it can never be certain to what extent the bad reasons operated on the mind of the authority concerned or whether the detention order would have been made at all if only one or two good reasons had been before them. Lordship, my respectful submission is that the grounds that the security of the state of Nagaland is endangered is irrelevant. And as far as the second ground, the public order is concerned, Your Lordship, that is irrelevant because the offense charged comes within the review of law and order, and it can be tried by ordinary course of law, Your Lordships. And the grounds, again, that the detainee has filed a bail petition, that itself will not make the detention order valid in the Lordships, because there are no material to show that he will be released on bail, Your Lordships. There is no guarantee that he will be released on bail, or even if he is released on bail, that he will commit certain activities which will be prejudicial to the state, security of the state, or to the public order, Your Lordships.
Yes.
So it is grounds alone, Your Lordship. The detention order may be quashed, set aside the approval order, the confirmation order, any other consequential orders, Your Lordships.
Yes.
Have this lawsuit. My lord, here the petitioner has taken 4 grounds. The first ground is non-application of money. That one he has pleaded in the writ petition. And ground number 2, not furnishing of applicable order. That one, my lord, and the delay in disposing representation and likely to release on bail, not mentioning detention order. These 3 grounds the petitioner has not taken, my lord, and it does not mention in the pleadings. So the petitioner is submitting beyond the pleadings. That is my first ground, my lord. So the Lordship may not accept these 3 grounds. Secondly, my lord.
First you say is non-application of judicial mind.
Petitioner has taken that ground,
Okay.
non-application.
Second is non-furnishing of the approval order.
Yes, that ground
And
he has not taken.
Third is
Third is delay in disposing of representation. This ground has not taken in the petition. And likely to release on bail, not mentioned in the detention order. This 3 ground, the petitioner is submitted beyond the pleadings. So, my lord, in regard to the first ground, application, non-application of money, my lord. So, my lord, the lordship may kindly see the detention order, ground of detention in the writ petition, page number 34. Page number 34, Annex 6. Married, my lord.
yes.
So and so, in the second paragraph, whereas the undersigned has made detention order against you under the provisions of the National Security Act 1980. Now, therefore, in pursuance of Section 5 of the said Act, the undersigned hereby inform you that the said detention order has made against you on the following ground. Number A, security of the state of Nagaland and maintenance of public order. The particulars which have bearing on the attached. The Lordship may kindly note this line. You are also informed that you have a right to make representation to the genuine authority, central government and state government through the concerned jail authorities. You also have the right to claim a personal hearing before the advisory board constituted by the state government under the aforesaid Act. My lord, this ground of detention should read along with the stones that is given. The Lordship may kindly see page number 35. That is the schedule, my lord. Page number 25. In the writ petition.
Yes.
Relevant paragraph. In regard to the petitioner, you also may kindly see page number 14.
Just only. What if
Page number 14. In the page number 14. Paragraph 1, 2, 3. Paragraph 3. On examination, accused 3.
yes.
Yes. May I read, my lord? These paragraphs. On examination, accused 3. So and so, he stated that he was born and brought up from the Sinitu village and he did his schooling from Saint Joseph Hospital till class 5. Married in so and so. He joined UG faction in the year NSCNR in the year 2020. Rank Lessing left NSCNR and joined NSNK Kamo 2024. When basic crime, he stated that he is in crime branch, civil wing, so he did not attend training and never visited NSCN Kamo or visited NSCN Kamo headquarters. On first week of December 2025, he was informed by Liban that Liban Kashan Inavi was working in a call center. Later, he along with the Itoy met Liban and he told them about the call center office. And accordingly, Itoy told the higher authority about the call center and the plan to raid the place on a decided. On 15/12/2025, the plan for the raid made and planned during the afternoon. He stated Tambo David brought this car although and he was told by Pichu to call Finance Secretary Alvaro Driver Wagoner R for help to use his car. Later on 15/12/2025, he along with Tambo Chopi, a widow, Aloto Lipan Doi met up at Signal Lomiti Junction. They were earlier training at Padang Bukri. The other party came in the tar rocks at Signal Lomiti Junction. They did not come down from the vehicle as they were carrying arms. Itoy went and met with the other members. They all gathered at Lomito Colony Junction at around 9:30 to 10 p.m. on 15/12/2025. He stated Inavi told Lipan to come to the house at around 10 to 11 p.m. Thereafter, they stopped at the Ayuntil Tree Junction and Lipan showed them the house and went back. At around 10 to 11 of them went inside the house compound with arms. They entered the house of the victim at around 11 p.m. He stated that one individual, the owner, was outside the house and as such, the military members first caught him at gunpoint to his head and took him inside the car. They all went inside the room led by the army team and apprehended the other victims in the room, during which one person fired the AK-47 3 rounds, and he does not know the identity. He stated he is the bodyguard of the other officer. After the gun was shot, some of the members took the laptops and mobile phone and they hurried out of the house. During the fight, Inavi got hurt and accordingly, he and Hitoy called Liban that Inavi was shot and told them to come pick up Inavi. He said Liban and Gabu were outside at the village junction. In Liban, Gabu was driving and they shifted Inavi to the Liban guard. He also stated after the incident, they moved out from the Bio during the halfway he along with Hitoy. Nambo changed car in an Alto belonging to Tambo and they directly left for Tiliku village. He stated while Alto was collecting the laptop, the gun was fired and the Volkot pick him up and left. Later, Aloto came to Tiliku to the office. Next page 42, para 3. That as per records made available by the sponsoring authority, the subject is active member of NSN Gamo, serving in the capacity of lessee. The subject, along with the other accomplices, had abducted the victims and also threatened the victim using automated weapons and demanded ransom money of ₹50 lakhs for the release of the abducted victim, thus acting in a manner prejudicial to the maintenance of public order and security of the state. The subjects are likely to move for bail and enlarging them on bail increases the possibility of the subject indulging in other criminal activities. Thus, there is every possibility of the subject indulging in similar prejudicial activities which will be detrimental in the maintenance of public order and have the potential to reshape the peaceful environment. The incident has also attracted massive public outrage and media attention, as the incident had occurred in a Islamic village, reshaping the peaceful environment. Wherefore, the subject is presently under judicial custody at Central Jail, Dimapur, and has moved for bail on 21/2026. If he is not detained, he is likely to indulge in similar prejudicial activities, unless an effective alternative measure is called for. On examination of the report forwarded by the sponsoring authority, the subject is found fit to be booked under the National Security Act 1980. Hence, in order to prevent him from indulging in activities prejudicial to the security of the state of Nagaland and maintenance of the public order, the undersigned has ordered the detention of the subject under the said act. This is the subject visa restriction, madam. It is clearly mentioned, madam, the prima facie of the case, why the detaining authority was compelled to pass the detention order. So there is no violation of any procedure laid down under the act and the detention order passed by the detaining authority to testify. That is my humble submission, madam. And the rest ground the petitioner has not pleaded in the petition, so I'm not justifying on those grounds. Lordships.
Which page is that approval order?
Page
Approval
15.
1550.
Lordships on the points submitted by the learned, maybe may I be allowed to give some points of rebuttal to the Lordships.
Just a moment.
Service.
Some confusion. Detention order is 22 January 2026
Yes, yes.
and approval order is 2/2026.
2 February, yes, February 2026.
Detention order body question, approval order to mean question.
This was approval order was served. Just wait, report master. It has been served to you on 4th. Oh, sorry, it's 2/2. On 4/2. We have an acknowledgement here on record.
Lordships, I cannot say on how it was recorded, but as far as our communication with the detainee is concerned, we had inquired, or even on 5th, whether any order had been received.
That we don't know. That's why we searched for it, because normally it doesn't happen.
Yes, Lordships. And then on 5th also, it was ascertained that the approval order was not received.
Just show it this record to you. Once it's there on record, it's you have to dispute it.
The Lordship will kindly see the ground. The writ petition. He has looked in that ground.
It's okay. But if he has there's something. Only it is wrongly mentioned. Here it is, instead of approval, it is a detention order. So there's a clerical mistake.
There is also in a sense of detention order considers it extended the period of detention.
Yes.
Lordships, this case is under.
Before you make your concluding argument, as the government advocate has stated, that in respect of the point not urged, he may not be well briefed. So you have a choice. Since it's a preventive detention orders, you may file an affidavit to bring on record the additional stand, or the stand which you are taking and is beyond pleading. We'll have to, we cannot consider, because we are hearing this in 6 days' time. Sorry, a week's time, I think. And he's not put to notice that this will be urged. So you have a choice. If you want, you can bring it by way of an affidavit so that he can take instructions, or those points which has not been urged in this writ petition will have to be, we cannot be considered. So it's your choice.
Lordship, in that case, I may be given the liberty to file additional grounds on Philippine.
Better do it, because otherwise he has made a strong point, and I also believe on the same thing. He's arguing without any affidavit on the basis of your request made on the last date. It will be taken up in a week's time. You must have appropriate instructions. Okay. We give him a liberty. This is preventive detention. He always have a right to make his submissions. This records can be returned. Mr. You say in course of his submissions, Mr. Z. Chisi, learned counsel for the petitioner, had made certain submissions. So, however, Mr. E. Tiva Form, learned government advocate, raises a preliminary objection that out of the points urged, few of the points are not supported by pleadings in the writ petition. Full stop. Next paragraph. Pursuant to order passed on 22/4/2026, the learned government advocate has produced the records relating to the detention of the petitioner, husband of the petitioner.
Wife of the petitioner.
Sorry, husband of the petitioner.
Yes, yes.
Husband of the petitioner. Full stop. Next para. In view of the submissions made by the learned government advocate, the learned counsel for the petitioner, prays for some time to bring on record. To file an affidavit to bring on record the grounds on which he assails the detention orders. Stop. Next para. Prepare is allowed. The additional affidavit shall be filed within week from today, week from the date of the order. Stop. That the advance copy thereof be served on the government advocate so as to enable him to obtain instructions. Next para. The affidavit as proposed be filed by 13/5/2026. List the matter on 20/5/2026.
What's over? For orders, item number 21.
Ladies and lordships, my lordship, I have spoken to the council who appeared on the last occasion. However, I was informed that the bar council of India engaged another council to that the
Name of newly engaged council, you have not got.
No, the shortcut call is sorry, by the email. It's matter. The interview are done to this is it's been passed. So we had actually, last order you had not taken. Okay, then record it. Miss Esther Chakre, CHAKHRE, who is the petitioner number 1, appears in person and submits that her counsel holding the brief has suffered a bereavement. And therefore, she prays to allow her to appear as petitioner in person for herself and also on behalf of the other 2 petitioners. Having heard Mrs. Sedan Nugli Lanet, CGSC, the prayer is allowed. And the petitioner number 1 is permitted to address the court in person. Next paragraph. As the cause list did not reflect the name of Mr. Foseco Hote, learned counsel for respondent number 2, who had entered appearance on 29/4/2026, the court had requested the petitioner number 1 in person to search for the said learned counsel and to inform him about the listing of the matter. Full stop. Accordingly, the petitioner number 1 in person has who was given some time to inform the learned counsel, has submitted that she had called the said learned counsel for respondent number 2, who has submitted that she was informed that the Bar Council of India had engaged another set of counsel, and therefore he would not be appearing in the matter. Full stop. Next paragraph is next paragraph. The issue raised in this writ petition is that the Bar Council of India is holding All India Bar examination, where several candidates from the state of Nagaland are appearing, but the examination center is located outside the state of Nagaland, and therefore the prayer in this writ petition is to direct the Bar Council of India to have a permanent examination center for the All India Bar examination in the state of Nagaland. Full stop. Therefore, when the matter was ordered to be listed on 6/5/2026, the respondent number 2, i.e. the Bar Council of India, was duly represented. Next para, it may be further mentioned that in the order dated 29/4/2026, this court has recorded that the notice was served on respondent number 3 by Dasti, but none appeared on call for the number 3. Full stop. In the meantime, the affidavit filed by the petitioner number 1 regarding service of notice by way of Dasti has been filed, and on behalf of the respondent number 3, one Kulesh Goswami, Kulesh Goswami, Goswami, had received the notice on 24/4/2026 under the rubber stamp of Secretary, Bar Council of Assam, Nagaland, etc. None appears on call for the respondent number 3. Next paragraph. For the government who will be appearing, respondent number 4 is the government. Show her a copy of the writ petition.
Don't we have served it to the additional?
Please show it to her. Are we asking too much by asking you to show it to her? Then this is State of Nagaland, Chief Secretary. So you'll appear for the state. Mr. Government Advocate appears for the respondent number 4. Next para. It may be mentioned that in the order dated 29/4/2026, the respondent number 1 was respondent number 2 was put to notice that keeping the issue of having an examination center in the state of Nagaland open, prayer for adjournment was allowed to the respondent number 2 to file affidavit in opposition or to make their submissions in respect of the prayers made in the writ petition. Full stop. Therefore, the conspicuous absence of the respondent number 2 to be represented can only be presumed to be an act of delaying effective orders to be passed in the writ petition. Full stop. Next paragraph. Therefore, having regard to the projection made in this writ petition that the examination of the Bar Council of India examination is scheduled on 7/6/2026, the court hereby issues a direction upon the Bar Council of India, New Delhi, within bracket respondent number 2, and the Bar Council of Assam, Nagaland, etc., within bracket respondent number 3, to forthwith make all arrangements to have one examination center for the All India Bar examination for the state of Nagaland, preferably in Kohima. Kohima is better placed or Dimapur? Kohima, okay. Yes, for the government, which is better placed? Kohima or any other place in the Nagaland?
Centrally.
Centrally, which will be better? Kohima, okay. At Kohima. Next para. The due arrangements shall be made by the respondent numbers 2 and 3 to do all what is needful to have the examination held at Kohima in the state of Nagaland. Next para. As this order has been passed ex parte on the neglect on the part of the respondent numbers 2 and 3 to enter appearance, the petitioner number 1 in person is directed to serve a photocopy of the certified copy of the order to the respondent number 2 and 3 by email at their addresses. Next, from a copy of Annexure D to the rate petition, it is seen that the email address of Bar Council of India within bracket, New Delhi within bracket respondent number 2 is bci info @gmail.com. And the said press release was issued by the chairman of the Bar Council of India, whose email address in this said letter is page 19. Huh? Just cross check that. It is Manan Kumar Mishra, MANANKUMAR MISHRA, one word. Manan Kumar Mishra @gmail.com. Full stop. The petition number 1 in person shall find out the email address of the respondent number 3 and transmit a photocopy of the certified copy of the order to the respondent number 3 also. Next para. It is further provided that the transmission of a copy of the order by email would constitute due notice to the respondent numbers 2 and 3 for due compliance. Next para. The respondent numbers 2 and 3 is also directed to give due publicity to the examination center to be set up at Kohima in the state of Nagaland, and shall also permit all candidates who are permanent residents of the state of Nagaland to opt for holding their examination, for appearing in the examination at Kohima in the state of Nagaland, and such requests shall be honored. Next para. Next para. As the order is being passed in the in the calculated absence of respondent numbers 2 and 3 to avoid their appearance in court, the court permits the respondent number 2 and 3 to file applications for modification of the order, if so advised. Next para. List the matter. Next para. The respondent numbers 2 and 3 shall be well advised to inform the court about the steps so taken. This will be before that, huh? And the modification application will be next para. To well advised to inform the court about the steps taken. Then that paragraph, and then next para, list on 2/05/2026. We may be late in resuming again. There's some program at the bar, so after that, we'll resume again.
For delivery of orders, item numbers 1, 2, and 3.
This will have to be listed before the appropriate bench. So it can't be delivered here. We have already prepared that order. As the matter is heard by a different bench, the registry shall leave the matter before the appropriate bench. Sorry, in the morning it did not strike us. When we saw everything, then we found that it was heard by another bench. Couldn't have been delivered today.
Your Lordships, the item number 34 is a challenge to a conviction order for life. It may take some time since the other matter, there is a part of heard matter also. Lord, we have a consensus request before the Zoom court to fix the matter after 3 weeks.
Item 34. Both sides are represented. Due to paucity of time, the matter stands adjourned today. List after 3 weeks.
Yeah, let's. I love the commission item number 24. I have to yet to get the instructions to go. That is 3 weeks time to get the instruction. I'm for responding to two.
Well,
Or a detention order has been challenged.
yes, Madam. And I have not made any allegations against the central government. I have not made any allegations against the central government. Therefore, if it is, his instruction is not present today, it will not affect him in any way. So I humbly request that the matter may be taken up today.
You have the records? But you'll have to wait. There's a pattern matter. We have to close that. Even after that, time permits.
For orders, item number 23.
Just wait for some time. After the pattern matter is over, this has to call because we will deliberate if the bench can be made available for this criminal writ petitions tomorrow. Just wait for some time.
For hearing, item numbers 37 and 38.
Please, Doctor. Doctor, I'm referring for his lordship's indulgence. If the two order items in the supplementary item will be taken up for you, they only 5 minutes. Because order whether may take little time. In the supplementary lordship, there are more items for orders.
Yes, right.
For orders, item number 47.
Yes. Yes, who's there? Item 47.
Mine is 48.
Okay. 47 is Nisuka Chishi. Left.
Item 47, so I filed an affidavit, so if it's a consensus based, that maybe it's the next week.
You have taken his consent.
Yes. It's
Okay.
consensus based.
Okay, with consent of the consent from the Learned Counsel for the petitioner. No, just say Ms. Learned Government Advocate submits that she has filed an affidavit in opposition to the matter today. So let the same be tagged with record. Next para. With consent of the Learned Counsel for the petitioner, she prays that the matter be listed next week. Next para. Prayer is allowed. List on 13/5/2026.
For orders, item number 48.
Lordship, on the 2nd of last month, we were directed to file custody for respondent number 4. Now it has taken effect.
Respondent number 5.
5, I'm sorry. Now, my friend, Mr. CBA is appearing for respondent number 5, so Lordship, this is complete. In fact, I have filed an affidavit also, but since he had appeared,
Delay of how many days?
15 days, Lordship.
You are seriously objecting?
No,
Okay. Okay. What?
Two minutes so that I look back on the unique situation here. Your Lordship is well aware that in Madhuri Patil versus Commissioner of Tribal Development, 1996 year, Lordship, the Honorable Supreme Court has given 15 directions for verification of caste and tribal certificates. Now, Lordship, direction number 1, 10, 14 to 15 is with regard to constitutional scrutiny committee, the procedures to conduct. My Lord. And Lordship, the direction number 11 is that, Lordship, finding of scrutiny committee is conclusive and is only subjected to 226. Lordship, direction number 12 is civil no suit or other proceedings before any other authority is barred. So civil court jurisdiction is barred. And Lordship, condition number 13 is no appeal before, no intra-court appeal, no division bench appeal, only directly to the Honorable Supreme Court under 136. That was the direction given, and Madhuri Patil then gave a direction that for all the states to constitute a scrutiny committee. Unfortunately, Nagaland is yet to constitute a scrutiny committee, so there is no appellate authority. Lordship, in such matters in everywhere in the state,
direction is given to file before appellate authority. Then Lordship equally appreciated the 15 directions were, there was a reference case in Diagram versus Sudhir Patam, 2012 one SEC. 3 reference, whether the directions 1 to 15 is impermissible being legislative in nature. Secondly, whether the direction number 12 in 13 excluding civil court jurisdiction is violating of section 9 of the CPC, and whether intra-court appeal is constitutional or not. That was the 3 direction, the 3 reference in Diagram's case. Now the Honorable Supreme Court, 3-bench judge has upheld that the direction is maintainable, and 15 directions were upheld. And also, Lordship, the Honorable Court upheld the fact that foreign civil court is maintainable, but intra-court is appealed before the division bench was modified. I have the judgment. If necessary, Lordship, I'll bring to your Lordship notice.
But just a moment, just to clarify my query. I'm sorry, I'm interrupting you. You see, your case which has been built up, if I have understood correctly,
Yes.
without aid of your assistance in
Yes.
reading it. I may make a mistake, but this is what I've gathered. You see, your case is that the principal, your projected father, had 11 children. And then subsequently it said that he had 12 children. And then the village council and all, they say that they had extramarital affairs. That is the facts.
If necessary, I'll make it the fact.
No, it's okay. But then you come, then it is projected in the writ petition that the DNA testing is required.
Not
Correct.
DNA testing. Yes, DNA testing was required, Lordship. Then I approach this Honorable Court. This Honorable give a direction that the no DNA testing on the available records. So there is sufficient evidence. So on the basis of the available report, decision to be taken. That was the direction. Accordingly, Lordship, accordingly, the Deputy Commissioner reassessed, was given direction. Now, the point is this, Lordship, the issue which I am raising here. The Deputy Commissioner is the issuing authority. Deputy Commissioner issues the certificates. Because in the absence of a scrutiny committee, Lordship, the Deputy Commissioner is also verifying his own decision, examining his own decision, he is the judge of his own orders. That is a unique situation here. So in that view of the matter, Lordship, my respectful submission to the little single judge was that, look, there is no, now what is the decision? My lord, the little single judge has taken a decision that para 39 page 81.
Yes.
The little single judge has held that under Article 226 of the Constitution, I have no power to reappreciate evidence. And under technicality, Lordship, the petition was rejected. Though he has discussed all the issues from paragraph, all the facts from paragraph 27, and Lord, he has discussed all the facts. After discussing all the facts, he said, I have no jurisdiction to sit as an appellate authority under 226. Now, the situation here is, my lord, there is no scrutiny committee in the state of Nagaland because Pratibha Bhadra's judgment has not been implemented. And I cannot go to civil court. And the little single judge has given a decision that I cannot reassess, I cannot sit as an appellate authority, and whatever has been decided by the Deputy Commissioner, I cannot interfere under 226. So the question is, where will I go? My respectful submission to the little single judge was that in view of the fact that the Pratibha Bhadra's judgment has not been implemented in Nagaland, there is no scrutiny committee in that particular situations, and civil court is barred. So my only option is to approach Article 226 with the request that in that particular facts and circumstances of the case, this honorable court has under 226 has to re-examine all the records available and make a decision. Now, what Lordship may highly appreciate this fact that in particular partition, perversity, violation of natural justice, and violation of the act or exception given. Now here, Lordship,
in this particular situation in the state of Nagaland, since there's no scrutiny committee, there is no provision for me to file an appeal before the appellate authority. And I'm barred from approaching civil court. Now, and the deputy commissioner who issues the order had re-examined his own decision and pass an order that on the basis of the available record, he denied. So my respectful submission before a single judge was that this honorable court in that particular facts and circumstances, which is unique to Nagaland, in the absence of a scrutiny committee, Lordship, this honorable court under 236 has to examine.
What is it, Kumari?
I'm giving the judgment. Lordship, I'm giving the judgment. 2012, 1 SCC. My lord, I have given the citation already before the Lordship.
Kumari Madhuri Patil.
Yes, my lord, in Diagram, the orders has been reflected. So that is so if by placing this judgment, you will offer both. If because of paucity of time, I'm not going to the detailed facts of the case. Lordship,
In this Kumari Madhuri Patil,
Lordship, yes.
if
Lordship,
I vaguely remember, there was a bar for the jurisdiction of civil court and even high court. It has to go to that scrutiny committee. That's the.
Lordship, yes.
Where is that
Lordship,
observation?
Your Lordship, you can let me right? Page paragraph 6 and words. The directions of Madhuri Patil is mentioned in paragraph 342.
Yes, it's there.
My lord, the directions in the Lordship, you can see from paragraph 6, the paragraph 7, you can read the directions starting from 1, 2, or the
No, because
directions
if I remember it correctly, it says that the appeals would go to the class scrutiny committee.
Yes.
Only against that order, writ petition would be maintainable.
Yes, I'm going to Lordship, 11, Lordship, you can see 11.
It's 343. Yes.
Then 12.
Huh.
Then 13. Then thereafter, this is a reference. Question for consideration. My lord, the Lordship, you can read 8 also, paragraph 8 also. Then the reference is given in from Lordship, the 3 questions are for consideration. Reference is in paragraph 9.
Yes.
Then Lordship, you can see the operative is paragraph 22, the first reference.
Yes.
Then Lordship, the second question in page 23, Lordship, you can see a paragraph 35.
Yes.
Then the third question, the paragraph 37, that is, Lordship will find in page 43, paragraph 43. And 44. Now, my lord, if you Lordship, you can see my ground of appeal number 1 at page 39. So, my lord, My submission before within a single judge was that
Just a moment, paragraph.
paragraph page 39, paragraph 1, that my grounds of appeal one, this motion, can you read that will suffice for them. Page 39.
Yes.
May I read also? For another single judge has failed to appreciate the important question of law unique to Nagaland, the Honorable Supreme Court in such, and it had in the exercise of power under Article 142 of the Constitution of India, he doubted that claimed on exhaustive procedural guidelines in paragraph 13 to streamline the procedure for issuance of caste certificates, their scrutiny and delegation thereof. A summary of the important guidelines are: application shall be made to the reviews of the regional officer and deputy collector or the commissioner. The parent or the guardian, as the case may be, shall file an affidavit duly sworn before a gazetted officer or non-gazetted officer with particulars of caste, tribe, etc. The state government shall constitute a strict scrutiny committee who has intimate knowledge in the verification and issuance of social status certificate. Each directorate shall constitute a vigilance seal. The director concerned on receipt of the report of the vigilance officer, if he found the claim for social status to be not genuine, lawful, rulely claim the director consulate should be so show cause notice. In case the candidate seeks for an opportunity of hearing, the director shall convene the scrutiny committee, which will give adequate opportunity to accuse all evidence in support of the claim. The order passed by the committee shall be final and conclusive, only subject to proceeding under Article 256 of the Constitution. No suit or other proceeding before any other authority should lie. No further appeal shall lie against the order to the division bench, but subject to special leave under Article 126. The appellant pays the leave. The Honorable Court by Rich Chance bench in Thailand versus such and such. In a reference to Madhuri Patil, the Honorable Court has clarified the right to appeal the division bench made available to a party to a petition. Either the statute or later patents cannot be taken away by a judicial order. The right to appeal is vested substantial right. The vested right of appeal can be taken away only by a subsequent enactment. Therefore, a second sentence of direction of Madhuri Patil case, where the lead petition is disposed by a single judge, no further will appeal will lie against the order, only be subject to special leave under 136 is not legally proper, and therefore to that extent is held to be not good law. The second sentence of the direction 13 stands for rule. As a consequence, permits an indirect court appeal in the same will be available. The Honorable Supreme Court has-
Just a query.
Yes.
You see, what we find from reading of the order of this single judge is that he, in page 64, paragraph 15, the learned just took into consideration direction passed in judgment and order dated 27/9/2021, directing the authority to make an inquiry.
Doctor.
Now, pursuant to that inquiry, the deputy commissioner passes an order.
Doctor.
Now, till the time that order dated 27/9/2021 is not recalled or is interfered with, you see, I'll tell you, I have a certain mental block, which I'll tell you, and therefore you'll have to make me overcome that.
Doctor.
Just give civil procedure code to sir. There's a cobweb, we'll have to clear it.
Doctor.
So order 26, rule 10, sub rule 2. Order 26, rule 10(2).
Yes.
Now this order 26 relates to issuance of commission.
Yes.
Yes, it will be not. Now this says the report and depositions to be evidence in suit.
Yes.
Now it need that suit to be a high court proceedings. Now you see what happens is that when the high court passes an order directing an inquiry to be made, that inquiry report becomes an evidence.
Okay.
I have authored an order where I've said, then in a writ petition, what would be an evidence? So in that, the pleading supported by an affidavit becomes an evidence, and reports which are created by virtue of orders passed by the court also becomes an evidence.
Okay.
This is under Order 26 Rule 10(2).
Okay.
Then the power of the court to ask questions is preserved under 165 of the Evidence Act.
Okay.
And 165 says that the order of the court would be dependent on that fact which has been inquired. So therefore, this is the principle which is consistently being followed. Whenever we ask by directions of the court, we ask an inquiry to be done, reports to be created and placed before the court. It has happened also in that many cases. You are more knowing of those cases than me. So you see, what happens is that this evidence is created by virtue of the orders of the court, and that report itself becomes an evidence. So therefore, I'll tell you the problem which I am facing. It's a prejudice, or what you call a cobweb, which you'll have to clear. Now, once the court says a direction by virtue of directions contained in that paragraph, an inquiry is to be made by an authority. And with that inquiry report, if the deputy commissioner gives a verdict, where will be the illegality? How can we now say that the act done by the deputy commissioner in reviewing its order would be beyond his capacity?
Well, that's what in the first place, my lord, the Honorable Supreme Court judgment is crystal clear. Civil CPC is not applicable, because the issue was whether Section 9, my lord, whether the Constitution, whether it is violative of whether in civil court is violative of Section 9 of CPC. That was the check. That was the reference. Court says in the negative. The division
is bad.
Civil court is barred, CPC is barred. My respect was sufficient, something in your direction, because the question was whether civil court is barred means application of CPC is barred.
No, by virtue of default, that the principles of CPC is.
Secondly, not. This one is sufficient doctrine. Secondly, whether the decision, whether the direction of the deputy commissioner to pass a decision after conducting a detailed inquiry, whether it was a commission appointed or it was an administrative action to be done.
See that judgment. It's annexed here.
It's the judgments. Lordship, if that is so, can you allow me to refer to the judgments?
Yes, 27/9/21. That.
My lord, the first direction is, your lordship will find at page 169. Lordship, can you allow me to go to page 169?
If I can, before you place that 169,
Lordship.
Please come to page 64. Paragraph 15 in the middle.
Yeah.
The court by its judgment and order dated 27/9/21 quashed set aside the order dated 16/6/2020. The Honorable Court also directed the Deputy Commissioner Kifayar to conduct a thorough inquiry by giving the stakeholders or the parties involved a chance of producing the evidence,
yes,
both oral and documentary.
Yes.
So this is a direction of the court.
It was done. Then lordship. Thereafter, pursuant to that, lordship may see, thereafter the second judgment, the second round of litigation is 169.
169.
Yes.
Okay. Yes.
The second round of litigation thereafter, lordship, is 169. Now, my lord, from page 87.
Yes.
176, page 176, paragraph 13 onwards.
Yes.
Now, This court has considered the inquiry proceedings by the commissioner, which was held on 2011-2021 and 4/2021. The issue that arise before this court is whether the petitioner is directed to report DNA test against the bill. A special protection is given by law to the status of legitimacy in India. The law is very strict regarding the type of evidence which can be held, which can be lead into rebut the presumption of legitimacy of the child. Before a direction is issued to have a DNA test, the counsel the party is required in as much as such case is constrained under personal liberty and therefore cannot be carried out without consent of the person concerned. In the circumstances where other evidence is available to prove or dispute the legitimacy to order of this DNA test should be refrained from being in as much as such test infringe the right of privacy impose us all and also have mutual social repercussion. Then I'm something is 16 not true. The learned counsel to respondent, number 6 is taken as preliminary objection that assuming whole and student units are not with parties and therefore the present petition should be dismissed on the ground of non-tender of parties. However, under consideration of the merit of the case in whole, this court is of the considered opinion that non-making the instance in whole and student union challenge and as necessary party would be not effective to the petitioner accordingly. The preliminary objection is rejected. Considering the observation made in the present petition, this court is of the considered opinion that the deputy commissioner will come to a conclusion on the basis of the inquiry proceedings held on 21/11/2021 and 4/12/2021. As this court intends to remand the matter back to the commissioner to take a decision on the basis of the details available and inquiry, this court refrains from making any observations. Accordingly, the deputy commissioner was directed to pass a judgment on the basis of the available reports. Then, lordship, that judgment, the deputy commissioner's order is lordship 100 and 160. 150.
150.
Lordship, it is a 248.
248. Because I'll tell you, the reason I'm asking you these questions, I have a pattern for asking these questions. You see, just give that Evidence Act also. Evidence Act.
Well, the simple question I'm raising, subject to the lordship's view, is that since in the particular facts and circumstances of the case, in the normal situation, lordship, after the deputy commissioner passed the order, the next continue in terms of protocol of this direction was for me to approach a scrutiny committee.
That's not there.
That is not avenue.
So whether Read Court can shut off the doors for you, that's your.
So, Manoj, and Read Court. On the other hand, Read Court, the Read Court is saying that under 227, I cannot reappreciate evidence. So, sorry.
Correct.
And only on the question of on that ground of technicality, the petition was rejected. Not refusing to reappreciate.
Because then you see, for that purpose, if you refer to the judgment of the Supreme Court in the case of Council for Agriculture, what do you call the Ayurvedic Sciences versus Bikartan Das. Then you will find that when it's a case of, it's a challenge to an order of an authority, it's a certiorari. And therefore the jurisdiction of the High Court reappreciate evidence is
there is an exception has been made by the Supreme Court, saying that if there is violation of principle of natural justice in this appellate situation, in this case of lordship past certificates, the Honorable Court has given a direction that the exception for a High Court to examine under 226 is that if there is perversity, if there is violation of natural justice, and if there is violence or errors, then under 226 also, evidence be reappreciated.
Yes, perversity is a ground in certiorari also.
The point here is, the deputy commissioner is the authority who issues the certificate.
Certificate, yes.
And since there is no appellate authority, Lordship, the deputy commissioner is examining his own decision and give a finding here. Is it not violation of principle of natural justice, or is it not a case of perversity? Secondly, Lordship, why I'm saying the unique situation in Nagaland is, state government, since the direction was issued as early as 1996 in Protocol 14, no appellate authority has been constituted so far, no scrutiny committee. Lordship, so in that particular facts and circumstances, Lordship, the only and civil court is barred. So the only option for me is to approach under 226. And in that particular facts and circumstances, my submission to the single judge was that in that particular facts and circumstances, the evidence has to be reappreciated, and on the basis of the available reports, decision has to be given. That was not done. So, my lord, in that view of the matter, my lord, the other grounds and evidence are there, but then I'm not going with the, I'm not those issues. Only on that legal point, my lord, my humble submission is a notice be issued, and within a short notice, the matter will be disposed of. There is no prayer for hindering. Because where will I go? Lordship, that has to be, that is the question. Where will I go? Because now I cannot approach civil court. Now, Lordship, there is no scrutiny committee.
Explain the scope. Why evidence should not be issued? Completely actions that is for the government, you are there.
Should this notice given of an additional AG?
The additional AG. No, we'll require further assistance, because if you see, our view is that in the intra-court appeal, notice is not a requirement. It has to be admitted. It comes for admission.
Yes.
So notice is not required.
Well, I had a discussion
So-
in the morning. It was easy, so I had a discussion with him, and he was.
Because then if we really issue a notice, admit it, then there will be another question which we'll address. We'll put the state to notice as to why directions should not be issued for compliance of the directions contained in Kumari Madhuri Patil by constituting a caste scrutiny committee. But the notice would go in that way, because
This I just want to, I'm preparing for school number 5. Now that there has been a series of litigations, and the point which has been raised by my learned friend is question of law. So, and on the last occasion, DNA test was directed, they declined. All these factors have to be taken into consideration.
you see, there is a reason I'll tell you.
Dr. Patel's case judgment will be applied on consideration of the sequence of cases, what has happened. So the issue of admission may be kept open, and that the matter will be taken up after 2 weeks. So that either it is Advocate General or Additional Advocate General And I believe considering the issues involved, the assistance of the Advocate General will also be required.
It will be required.
It is up to the government. And so far as my role is concerned, it is limited.
We
To the
understand.
extent that I'm acting like a post office only in this matter. That whatever it is sent, then we'll select and send recommendation to them.
No, correct.
But then the
You're there,
issue of,
right.
law, I will also try to assist.
Yes, for non-compliance with the judgment of the Honorable Supreme Court, and make this.
Whether that will be relevant in the given context in our case or not.
You
that
see,
will
there
have to
I have a
be said.
negative, that's why I gave you those sequence. If there's a judicial order directing the authority to make an inquiry, can we sitting in a collateral proceeding, can say that no, despite that, it has to go to class scrutiny committee. That was the issue, number one.
Oh,
Second is that you see when, as he says that about the denial of the DNA. Denial of the DNA in a writ petition is permissible. You see, that's why I gave you this Evidence Act. The issue would be under 112 of the Evidence Act as to whether whether there is a relationship between the two. You will remember the famous case of N.D. Tiwari.
Yes.
There, when he stood the dog, the question came that he has to give a DNA test.
In the basis of the obligations, those issues were raised by me.
But the DNA test in the writ petition was a wrong.
But then
Wrong
option, the judgments of the most subsequent judgment is after the Indian Gauhati, that the option is there for the petitioners. So
But not in
whether
the
to go for
petition.
either this or not.
Not in the
option is
petition.
the petitioner, to
Not
the
in the
parties.
petition, but
So that has been appealed. And listening to it.
The direction of Honorable Supreme Court is not complied with by the state. And all throughout this litigation, all round of litigation, where the inquiry has been directed to be conducted by the state, the petitioner could have appropriately raised all these points. But why is the date of the day?
The question is
Like the
this,
state,
earlier round of
coming with
litigations, in the, I ask me, in the first round of litigation, this honorable court has struck down the issue of the order of the deputy commissioner and the violation of principle of natural justice. So we cannot go beyond that and say that after striking down, court gave a direction that conduct an inquiry. And accordingly, the inquiry was conducted. Then after the inquiry was conducted, the deputy commissioner came to a conclusion that on the basis of the evidence, he did not come to a conclusion, so DNA test. We approached this honorable court against the DNA test. Then this honorable court set aside that deputy commissioner's order and give a direction that look, you have sufficient evidence. So on the basis of the evidence, you can take a decision, so we take a decision. And that decision, and in that decision, the deputy commissioner has simply reiterated the earlier decision, which was set aside by this honorable court. Now, thereafter, I approached this honorable court, defending the petition that look, in that particular facts of situation, now the deputy commissioner has come to a conclusion. So, in the absence of a scrutiny committee and as per direction of the Supreme Court judge, no Supreme Court, kindly take a decision on the basis of the evidence and the reports available.
actually, that's why we are showing all these things. You see, when it comes to the evidence, then what has happened was that he denied for the DNA tests. Then the authorities, while looking into the aspect, found out that in his PPA order, the 11 children's name were there, but this name is not there, and therefore, you see, under 112, what is required? There is only one judgment where this 112 has been used in favor of the petitioner. The case was that whether he is the son of A or not.
Yes.
So in a particular writ petition, the finding arrived was that he produces a school certificate of admission in class 1 by the which was filled up by the father. Father gave that declaration in the school, and therefore, on the basis of that, it was accepted that the father, having declared him to be a son while in the school admission, was his father, and that is how 112 was examined.
That point of view, those judgments subsequently to Indian Gauhati, it was applied in the subsequent judgment which I have relied. Now, my lord, in my school certificates, my father is shown as Sema, Sunil. My matriculation certificate, all the documents, my certificate, certificate in my official in my educational documents. My father issued us photoshisumi. Now, the only ground why the deputy commissioner has rejected my plea was that in the pension certificate, in the pension document,
The name is not there.
I'm shown as beneficiary of Anil Goban, my foster
Yes.
father, and not my father. Now, from my childhood, because out of as Lordship pointed out of extramarital affairs, I was given birth, and since the wife of my father refused to accept it, so I was brought up by my aunt and her husband as their foster parents, a foster child, all along. So out of that, she was given, her name was entered as a beneficiary in the pension document. So that was only on that basis. My lord, in the earlier round of the education, the deputy commissioner has held that I am the daughter of Amir Roman. Not other documents, only on the pension document, only on the pension, only on the, my lord, service record of Amir Roman. So, my lord, those issues have been dealt with in the
Now you understand what I was saying. There is a direction of the court to make an inquiry.
Yes.
That inquiry was made, culminated into an order. Now the order reports.
Right. Inquiry has been conducted. And it has come to a conclusion, and it is culminated to an order. Now the question which I am raising before your question, is that whether that judgment order of the deputy commissioner is final for eternity, or I have an option to appeal. And now the option to appeal, as per Pratika Patel's direction, was to before a scrutiny committee, and that is not available. So where will I go? And civil court is barred, because lordship, besides the question of getting a job or losing a job, the question of my identity matters. So I come to the civil court to determine who is my father. That's why, considering all this background, the best thing would happen, the petitioner would happily accept the order to undergo for DNA. It has declined. That speaks for itself.
We don't know. This is something we want enter into the debate.
The principle of this epsilon equator will be very much applicable in this case.
I don't know, we'll not comment right now. Okay. Had Mr. Takamasa and senior counsel, assisted by Mr. Learned counsel for the appellant. Also heard, please record their name. Her name as government advocate for respondent numbers 1, 2, 3, and 4. And Mr. City Zamir, the senior counsel, assisted by Mr. Ozikum as counsel, A. Ozikum, done counsel for respondent number 5. Next paragraph. In view of the issue raised in this intercourt appeal, that in the absence of a caste scrutiny committee as mandated, the creation of which is mandated by the judgment passed by the Supreme Court of India in the case of Kumari Madhuri Patil, I think
Madhuri Patil versus State of Maharashtra. This is what I have seen in the record.
I think it is Kumari Madhuri Patil.
Kumari.
I don't know, I just check it. 94 6 SC 241. 1994, 6 SCC,
241.
6 SCC, 241. এটা কি করি? নাম কুমাৰী মাধুৰী লেখা আছে, ওপৰত মাধুৰী বুলি দেখিছে, গৈ আছে।
ইয়াতে মাধুৰী বুলি ৰেফাৰেঞ্চটো দিছে। চাৰ্কেশ্যনটো সেনেকে আহিব খালি। মাধুৰী দেখি থৈ দিছে।
Okay. It is actually Kumari Madhuri Patil, but the citation is Madhuri Patil.
Yes.
Okay. Madhuri Patil, MADHURI, Patil PATIL versus Additional Commissioner, Tribal Development and others, 1994, bracket close, 6 SCC 241. The appellant would be debarred from asserting the order of recalling of the tribe certificate issued in favor of the petitioner by the Deputy Commissioner, who is the authority, who is the authority who had originally granted the certificate.
Yes.
Next paragraph. As the issue relates to the non-creation of the Caste Scrutiny Committee by the state of Nagaland, the court is inclined to admit this appeal for hearing by issuing rule returnable forthwith, returnable in 4 weeks without requiring any steps to be taken. Reviewing 4 weeks. Requisite extra copies of the memo appeal along with all inclusions be provided to the learned government advocate. You have received it within 2 days. Next paragraph. As the issue relates to establishment of a caste scrutiny committee as per the tribe scrutiny committee as per the directions contained in the case of Madhuri Patil within bracket Supra, the court is inclined to issue notice on the Advocate General of the state of Nagaland, whose extra copy of the memo appeal be provided to the London Government Advocate for service to the Advocate General. To the Learned Advocate General, next para, list after 4 weeks.
Much better. Chips, items 45 and 46. It is judgment against Mrs. Swarnakari. Now, only for today, you hear the matter, I think time may not permit. So may I pray that this matter may be listed as a first item in the hearing on 13th.
We may not say first item, but
earlier order was also there that it shall be heard out of 10.
You'll have to make a prayer for upgrading. Just give that record.
Item 45 and 46. And then item 48 in the supplementary list is also listed for hearing. 49. This may be adjourned for 2 weeks also.
At item 49.
Yes, in the supplementary list.
49, due positive time matter could not be taken up today. List after 2 weeks. Okay. Okay.
Up to 1 week, Mrs. Justice Lamunda will see, so it will not be possible to be taken up for another 2 or 3 weeks. So on 13th, also, that is next week.
Next week.
Wednesday, Division Bench day.
Okay. What says the represented? Due to positive time matter could not be taken up today. Next one is In your order dated. No, Judge, list on 13/5/2026. Next, in view of order dated 29/4/2026, the learned senior counsel for the appellant is permitted to make a prayer for out of turn hearing.
Your Lordship, I will mention item number 36. This also has been fixed and it has been pending since 2
Can you
years.
go to the next bench? We can't avoid.
Learned counsel is outstation. My lord, just Senator Advocate Kiran Chowdhury, and it has been pending since 2024. The letter be fixed on 13th.
13, we have already fixed 2 or 3 matters. I think it will be difficult on that day to take up. We fix it on 20/20.
After 19th, he said that he will not be able to attend to it. That's why.
Same order, due to both sides are represented or due to positive time matter could not be taken up today. List on 13/5/2026. It may be difficult on that day also.
Yes.
Looking at this volume. Yeah.
Previous relationships, I will be allowed to mention here item number 44. Due to positive, this matter may be disconnected 2 weeks.
Okay, that is, all of this will go. You don't have to make a mention. All of the matters will be after 2 weeks. Whatever is left out in this today. Yes, Mrs. Yomi, your matter.
Yes.
This matter and there are 2 criminal writ petitions.
Can we try to go then?
That's what we are thinking.
Let's consider the jurors out.
Let's ask him how much time he will take.
How much time would take?
I have prepared the bullet points. Just one more document which I refer your lordships to, and then I'll conclude.
So we can have the bench at, there are 2 criminal writ petitions also. We'll have it at 3:30 tomorrow.
Very well.
Learned counsel who are there with the criminal writ petitions will list the matter tomorrow. If time permits, otherwise it has to go to the next bench. So that this 4, there are 3 items, 2 criminal writ petition, item numbers 24 and 23 and 24.
23.
23, 24, and then your matter is item number
37 and 58.
37, 38. In 37, 38, you write, as this being a parted matter. No, sorry, you say both sides are represented. As this is a parted matter which could not be taken up today due to paucity of time. List again on 7/5/2026. Preferably at 3:30 p.m.
At 3 p.m. So let me see the litigation is mentioned.
It's a single read.
Because you see, tomorrow the single bench is also there.
Yes, sir.
So we have difficulty in managing our time. So criminal writ petitions are there,
Yes.
and you said that you will hardly take some time.
Yes.
So I think 3:30 would be over. We able to manage.
Very good.
So, in fact, I have to apologize today to the bar for taking up that.
That was a very insightful discourse.
No, not that, but it has affected the court work. We are extremely sorry. This is the primary work.
That's also good, actually, when I was speaking.
Sorry, the court time we couldn't manage today. Preferably 3:30. And in these 2 other items, I have criminal writ petitions also say the same thing. This will not be parted. In criminal APC, say both sides represented, due to constitutional matter could not be taken up today. List on 7/5/2026.